Good morning. I very much appreciate our obedient Federalist Society crowds. Thank you all for being here this morning. I'm Dean Reuter, Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. Thank you all again for being here, and welcome to the second and best day of the Federalist Society's National Lawyers Convention. We did have a great first day, I will admit, and a great night last night. Should be observed, we had 4 justices in the room at dinner, and so of course that means we couldn't really decide a case, but you might look for a cert grant coming out of dinner last night. And there's some additional good news and bad news from the dinner last night. I don't know if everyone was able to hear the announcement last night that Justice Brett Kavanaugh, that's an applause line, by the way, Justice Brett Kavanaugh, that Justice Brett Kavanaugh will be next year's dinner speaker. So that's the good news. The bad news, of course, is the dinner's sold out. So. I want to bring to your attention a schedule change that you can find on your convention app if you've downloaded the convention app, and that's that this panel's been extended by 15 minutes, and it's going to be followed by a longer than usual break of about 30 minutes, and then we'll begin lunch service at 11:45. So the theme of this year's convention, of course, is regulatory transparency and good government, and that's something I'd like folks to keep in mind as we move forward through the convention content. At least one aspect of the discussion on regulatory transparency and good government, I think, is being deliberate about taking stock of where we are. Are we moving forward? Are we making progress? Or is the administrative state moving past us, maybe even overtaking us? And of course, when I think of things like that, that reminds me of a very brief story. My mother told me this story about 30 years ago or so, and she told me it as a true story. So you have to picture me 30 years ago. I look pretty much the same then as I do now. That's not supposed to be a joke, Harry. Anyhow, my mother was a PhD psychologist, and my parents were, at the time of this story, living in Northeast Ohio. And that's the part of the state that gets the lake effect snow, where they measure snow in feet rather than inches. I don't know if you've been there, but my mother was not the most confident or comfortable driver, and to get back and forth to her job, she had to brave the Ohio Turnpike, often on dark, snowy, wintry nights, all by herself, to get home from her day's work. And she recalled to me this story, one particular nighttime drive. She had a white-knuckle grip on the steering wheel. Her headlights were piercing the otherwise pitch-black void ahead of her. Large snowflakes were careening past. Her windshield wipers were thumping rhythmically. She was following the car ahead of her, led by its dimly visible hazard lights. And she was keeping a safe distance, trying to see through the blowing snow, which was accumulating on the road surface. She had her radio off, and her concentration was all focused on the road ahead. And her speedometer showed a steady 35 miles an hour. And then she was nearly startled out of her mind when there came a knock at her driver's side window. And a state trooper was standing there, gave her the universal signal for roll your window down, which she did. And he said, "Are you okay?" And she said, "Yes," mystified. She took a quick glance at the speedometer, and it still read 35 miles an hour. And of course, she wasn't moving forward at all. She had, for some indeterminate period of time, been stuck in a literal rut. Her speedometer cable linked to the front tires that were spinning, registering the false 35 miles an hour. And the car in front of her was stationary with its hazard lights on, but the snow blowing across and over her windshield gave her the illusion, only the illusion, of forward progress. So I'd like us to keep that in mind.
Hey, Dean, you'll be happy to know that NHTSA has a rule for that right now.
They do. Just the one rule, Steve?
Never just one.
So yeah, do keep in mind as you go through and you hear things today and tomorrow, whether we're making progress. I think it's important to keep that on track. But anyhow, I'm very pleased to introduce the moderator for our second showcase panel, Judge Michael Brennan. I think this is his first time moderating a panel at the convention. And Judge Brennan is true Federalist Society family, having years ago deftly wooed and then married not just a Federalist Society member, but a Federalist Society staff member. And that alone, I think, is a very concrete demonstration of the power of the Federalist Society network. Mike went to Notre Dame Law School, Notre Dame undergrad, and then graduated from Northwestern University Law School. It's a very fine law school indeed. In reviewing his bio, I realized for the first time that we overlapped for a year there, Mike. And I'm not going to tell you which of us is the younger, whether he's younger or I am, but of course you're all lawyers, so you know if I was younger, I would claim that. Judge Brennan clerked on the district court, and then he clerked for Judge Mannion on the circuit on which he serves today. He's served in private practice. He's served for nearly a decade as a Milwaukee Circuit Court judge, and we're just very pleased to have him with us as our moderator. So please join me in welcoming the very youthful Judge Mike Brennan.
Good morning. Welcome to our second showcase panel, Balancing Insulation and Accountability of Agency Decisions. Since 1981, by executive order, which was renewed in 1993, each U.S. president has directed executive agencies to maximize net benefits to society through a cost-benefit decisional rule. Regulatory agencies have sometimes interpreted their authorizing statutes to limit or prohibit this approach, and they may enjoy deference from courts when doing so. Many regulatory experts have expressed concern over agencies' failure to ensure that their decisions do more good than harm. This state of affairs raises certain questions, some of which we're going to discuss today. I'd like to list three of them. The first, how are executive and independent agencies to be held accountable for their actions while also preserving needed insulation from overbearing political pressure? Second, does the answer change depending on the mission of the particular agency? And third, are there problems with the cost-benefit analysis model that create opportunities for agencies to manipulate and justify their actions? Our four distinguished speakers will speak to these and related questions. I'm going to begin with some brief biographies, and then we're going to move to short presentations by each of the speakers at their seats on their initial thesis statements on our topic. That will be followed by a roundtable discussion and then questions from the audience. Our first speaker is Steve Bradbury. After confirmation by the United States Senate, Mr. Bradbury was sworn in November of last year as the 23rd General Counsel of the United States Department of Transportation, which has more than 55,000 employees and a $79 billion budget. Before joining DOT, Mr. Bradbury was a litigation partner at Deckert LLP in Washington, where his practice focused on regulatory enforcement and investigations, rulemaking and judicial review of agency actions, appellate cases, and antitrust matters. From 2005 to 2009, Mr. Bradbury headed the Office of Legal Counsel at the United States Department of Justice, where he advised the executive branch on a wide range of constitutional and statutory questions. He served as a law clerk for Justice Clarence Thomas on the U.S. Supreme Court and for Judge James Buckley on the D.C. Circuit. Second, we'll hear from Dr. Cary Coglianese. Dr. Coglianese is the Edward B. Shills Professor of Law and Professor of Political Science at the University of Pennsylvania, where he currently serves as the Director of the Penn Program on Regulation. He specializes in the study of regulation and regulatory processes with an emphasis on the empirical evaluation of alternative regulatory strategies and the role of public participation, negotiation, and business-government relations in policymaking. Before joining Penn Law, Dr. Coglianese spent a dozen years on the faculty at Harvard University's John F. Kennedy School of Government, and he also has taught at Stanford and Vanderbilt. He is a public member of the Administrative Conference of the United States and chairs its Committee on Rulemaking. He is also co-chair of the American Bar Association's Administrative Law Section Committee on E-Government. He received his master's in public policy, his law degree, and his doctorate in political science from the University of Michigan. Third, we will hear from Susan Dudley, who is the director of the George Washington University Regulatory Studies Center, which she established in 2009 to raise awareness of regulations' effects and improve regulatory policy through research, education, and outreach. Ms. Dudley is also a distinguished professor of practice at the Trachtenberg School of Public Policy and Public Administration at George Washington University. From April 2007 through January 2009, Professor Dudley served as the presidentially appointed administrator of the Office of Information and Regulatory Affairs, OIRA, which you'll hear about obviously this morning, in the U.S. Office of Management and Budget. Prior to that office, Professor Dudley directed the Regulatory Studies program at George Mason University and taught courses on regulation at the George Mason School of Law. Earlier in her career, Professor Dudley served as an economist at OIRA, as well as the EPA and the Commodity Futures Trading Commission. Professor Dudley holds a Master of Science degree from the Sloan School of Management at MIT. Fourth, you will hear from Katherine Sharkey, who is the Crystal Eastman Professor of Law at New York University School of Law. Professor Sharkey was a Guggenheim Fellow and a Rhodes Scholar. She received a Master's in Economics with distinction from Oxford University and her law degree from Yale, where she was the executive editor of the Yale Law Journal. After clerking for Judge Guido Calabrese on the U.S. Court of Appeals for the Second Circuit and Justice David Souter of the U.S. Supreme Court, she practiced appellate litigation before joining the faculty at Columbia Law School. Professor Sharkey has taught at NYU School of Law since 2007. Professor Sharkey is an appointed public member of the Administrative Conference of the United States, and she previously served as an academic consultant to the Administrative Conference. So we'll begin with short statements from each of our speakers, beginning with Mr. Bradbury.
Thank you very much, Judge Brennan. It's very much an honor to be here this morning, and I'm very impressed to see how many folks turned out for the early morning panel. I apologize. You may have known that the original speaker for the panel in this slot was going to be Naomi Rao, but she's otherwise occupied with looking toward her new post, so, which is wonderful, awesome for the country. So you'll have to put up with me as a second best, I guess. I'll try. I want to make 3 points to kick off the discussion this morning. To address the executive branch-wide interagency review process that Judge Brennan referred to. And the first point is that it's a proper exercise of the President's authority as Chief Executive Officer for the federal government to require, as all presidents since President Reagan have done, that executive agencies submit proposed significant rules to the Office of Management and Budget, specifically to the Office of Information and Regulatory Affairs, OIRA, within OMB. That's the office that Naomi Rao currently heads up, for a consistent, rigorous interagency review of the proposed rule, and specifically an analysis of the cost impact of the rule and the benefits of the rule, and a determination that the measurable benefits expected to result from the rule will justify, or in the words of President Reagan's original version of the Executive Order 12866, outweigh the expected cost impact of the rule. It's viewed as, and Supreme Court has recognized this, it's viewed as an inherent component of the reasonableness of rulemaking, that there is a rigorous attention given and analysis, economic analysis of the costs and benefits of proposed regulations, and a determination made that the benefits expected to flow from the regulation outweigh or justify the expected costs of the regulation. And in addition to the 12866 cost-benefit analysis, of course, President Trump has introduced 2 additional structural requirements in the management of the interagency process for reviewing proposed rules. Those are Executive Orders 13771 and 13777. Those are the rules that require departments and agencies of the executive branch to ensure that for every new cost-imposing regulatory rule, significant regulation, that's one that is expected to have a very substantial cost impact for the most part. The agency must identify 2 deregulatory actions it's going to take. And this so-called 2-for-1 rule imposes structural discipline on the management of each department and agency, because for the first time they are required to do this on an agency-wide basis. So sort of managing their own internal regulatory process. There's lots of agencies like ours, the Department of Transportation, have a lot of sub-agencies and subcomponents. And now those subcomponents in their regulatory rulemaking activities are not isolated islands. They are to be managed across the whole department by the department head. Second, the President required as part of this executive order that there be 0 net costs imposed by new regulations in this administration. Again, a structural, executive branch-wide, and for each department, department-wide management tool for ensuring a reasonable, thoughtful, and rigorous review of proposed regulations. And also the President in 13777 required agencies to set up regulatory reform task forces and to designate regulatory policy officers and regulatory review officers that manage this process on a department-wide basis, again imposing that structural rigor. These tools are a matter of management process management tools. They do not at all negate the statutory discretion of agencies to exercise substantive judgments about what is a proper use of their regulatory authority. They don't prevent agencies from developing and relying on technical information, specialized information that's within the expertise of the agency. And so, for example, at the Department of Transportation, where we have a critically important safety mission, these regulatory management tools do not at all interfere with our ability to carry out that important statutory mission, even though as a department we have achieved not just a 2-for-1 record in this administration in terms of deregulatory to regulatory actions, but a 23-to-1 record. So we're pretty proud of that. These executive branch-wide management tools that the President imposes through OIRA and OMB are critical to the President's ability to supervise the efficiency of the executive branch. And that leads me to my second point, which is that it's consistent with the Constitution and with statutory law for the President to require that all agencies of the executive branch submit their significant regulatory proposed rules to OIRA for this interagency process. And that includes the agencies whose heads are insulated from removal by for-cause removal restrictions, sometimes referred to as independent regulatory agencies, typically multi-member commissions or bodies, often with a party diversity requirement in the appointment. And the point I'm making is that the President can require those agencies to submit their significant rules to the same interagency review process without, and this does not require the Supreme Court to reverse its decision in Humphrey's Executor that upheld the constitutionality of those for-cause removal restrictions. And I think that's easily understood if you realize that this interagency review and cost-benefit analysis process is the way the President ensures that the executive branch is operating efficiently. And if you look at those for-cause removal restrictions that Congress has put in place, they typically empower the President to remove the heads of those agencies for dereliction of duty, which means not following a correct interpretation of the law, for malfeasance in office, for corruption, not acting for the right reasons, for example, and 3, for inefficiency. So the President has statutory authority consistent with those for-cause removal restrictions to ensure that those regulatory agencies, we're talking about like the Federal Trade Commission, Federal Communications Commission, SEC, for example, are operating efficiently. And that means he could require them to submit their rules to interagency review to ensure that they are applying a consistent and rigorous cost-benefit analysis to determine the justification for their rules. And they are coordinating that review across the executive branch to ensure there's consistency in analysis across the executive branch, and there's not interference with the programs and activities of other departments and agencies. So other agencies can have a chance to communicate through OIRA and comment on the proposal, and OIRA can review the consistency and rigor of the cost-benefit analysis. The last, that would be a change. I mean, it's been discussed a lot. ACUS has analyzed it, commented, and recommended this. President Obama actually amended the cost-benefit executive order to say that these independent regulatory agencies should submit their significant rules to OIRA. And what I'm saying is I think the president could require that they do, consistent with the law. The last point I want to make quickly is that it's a critical element of the president's management of the process to ensure the integrity of the interagency communications of that process. And to the extent there are confidential, deliberative communications between agencies and Office of Management and Budget, or between agencies that are reviewing proposed rules, the president has to be able to protect the confidentiality of those communications when they are sensitive and when the disclosure would compromise the integrity of the process. So I know Judge Brennan introduced the question of transparency and open disclosure, and certainly in rulemaking we want the agencies to disclose the basis for their decisions, the information they rely on, and the comments that they receive from outside parties that they do rely on. That's an important part of the process. But at the same time, the deliberative interagency back and forth, particularly with Office of Management and Budget, is important, and the confidentiality of that is often important to protect the integrity of the process. And therefore, statutes passed by Congress that would purport to require the disclosure of all of those interagency communications or communications between the agency and OIRA as part of the interagency review process that would require those communications to go into the rulemaking docket raise serious constitutional issues. And to the extent the president determines that that requirement would be inconsistent with the integrity, preserving the integrity of the decision-making process, I think there's a strong argument that those requirements would be to that extent unconstitutional. So with those perhaps provocative points, I will rest my case. Thank you.
Thank you. Dr. Coglianese.
Thank you very much for the opportunity to be back here at the Federalist Society to speak today. I'm going to talk also about independent agencies, and I'm going to get around to talking about the application of regulatory analysis requirements to so-called independent agencies. I'll have, I think, a different proposal to put out on the table than to bring the so-called independent agencies under the rubric of the executive order on regulatory analysis. But really what I want to do is I want to talk today about the distinction between so-called independent agencies and executive agencies. And I want to suggest that the better concept, as we are discussing on this panel, balancing insulation and accountability, the better concept is probably one that might be labeled or thought of as autonomy, rather than having a strict binary distinction between independent and executive agencies. And that probably is even still better way to think about this concept of autonomy is, as Harvard anthropologist Sally Falk Moore once wrote, as a notion of semi-autonomy. And so what I'm going to do is try to explain what I think would be different about thinking about autonomy as the focus and semi-autonomy, and then what that might say about how to approach the issue and concern that so-called independent agencies are not doing as thorough or thoughtful regulatory analysis before issuing new regulations. Let me just suggest at the outset that the focus of autonomy is intended to go beyond formal structures of agencies like the for-cause removal protection. It is a way of capturing a broad theme within administrative law that focuses on the importance of neutral expertise and not partisan ideology as a driver of decisions within administrative government. In fact, one could say that the notion of a government of laws and not of men or women suggests an autonomy to law itself that is often viewed as highly desirable and valuable. But it's that same separation, that same autonomy that is also valuable within administrative government, the carrying out of law enforcement and administrative functions in a neutral, expert manner, that advances public value choices that are reflected in law, but that it doesn't really, it's not driven by, government is not driven at the administrative level by personal or political preferences, at least not of the prosecutors or administrators. And I think much of administrative law reflects this desire for autonomy. One can take a look at the Supreme Court decision in the State Farm case, for example, and we may hear and discuss more about that. But in that case, the court made clear that the arbitrary and capricious standard in the APA calls for agencies to make decisions based upon reasons and a careful consideration of evidence, and not necessarily just on a political decision from a change, say, in administration in that case. So in other words, autonomy is important to ensure that administrative government is based upon sound science, on evidence and expertise. That is what we're really after. And then I think once we begin to focus on that operational autonomy as a value for government, we can look at the formal distinctions between independent and executive agencies that, again, often characterized or distinguished based upon the presence of a good cause or for cause removal limitation. We can view that formal distinction as having a contingent relationship with autonomy, that it may or may not advance autonomy. I think this is important for a couple of reasons. First, moving past that formal distinction is important because both under the traditional dichotomy between executive and independent agencies, both kinds of agencies should have some degree of autonomy. That's important for both types of agencies. And that contingent relationship between the formal structures and the actual level of autonomy suggests that we should look beyond that formal distinction and ask what's really happening. And I think a good bit of current research on the nature of agency independence is showing us that. I mean, Ricky Revesz and Curdy Datla have a nice article that show even at a structural level what constitutes independence of an agency is a continuous, not necessarily a binary distinction. And autonomy itself is definitely on a continuum. For many years, the OECD has been recommending to governments around the world that they promote independence of regulatory authorities by using formal structures. But most recently, in their most recent report on agency and a regulatory independence, the OECD has recommended not focusing solely on the formal structures, but recommending a shift to thinking about the de facto independence or autonomy. Autonomy also is helpful, I think, in expanding the scope of the pressures that can affect, that we need to be concerned about affecting governmental performance. The formal independent executive distinction really focuses squarely on the president's role in the day-to-day shaping of administration. And that's one facet of autonomy, but so too is autonomy from pressures from special interest groups, as well, concerns about regulatory capture, as well as pressures from unrepresentative congressional committees, Hugh Hecklow's notion of iron triangles. It may also help us think harder about and understand more clearly the calls to separation or a degree of insulation from judicial oversight, at least in the Vermont Yankee sense that the court said that the judiciary, an unelected, undemocratic institution, should not be adding to procedural requirements or otherwise driving the direction of the administrative state. So both as, I think, a positive or explanatory or descriptive matter and as a normative or legal matter, agencies, I think, should strive toward autonomy, and yet they should not be fully autonomous, and they should be accountable as well. And this is where I think the notion of semi-autonomy comes in, a notion that goes back at least to 1973 in a famous article by Harvard anthropologist Sally Falk Moore, who spoke about law itself as a semi-autonomous force within society, an institution that is both shaped by society, social and political factors. At the same time, it is also trying to shape society, social relations, political conduct, and so forth. Law, in a semi-autonomous sense, is much like the bank of a riverbank does shape the direction of the flow of the water, but sometimes that water itself, if that's a metaphor for society and social pressures, bumps up against the riverbank, maybe overflows it, and shapes the direction and shape and angle of the riverbank itself. The challenge with semi-autonomy then is finding what one might consider the optimal degree of semi-autonomous administrative agencies. It recognizes the mix that Chris Edley spoke of when he talked about the trichotomy of administrative law, science, and politics mixed in there together. I think this notion of semi-autonomy, of breaking free of the binary distinction between independent and executive agencies, also can give us some purchase on and some direction with respect to questions of the design of the administrative state, and particularly with this issue about regulatory analysis. So let me just close briefly with a different way of approaching the need for and desire for improving regulatory analysis at the so-called independent agencies, the Securities Exchange Commission, Federal Communications Commission, Federal Trade Commission, and so forth. Lots of studies have shown that these agencies don't do as much regulatory analysis as best we can tell, as so-called executive branch agencies. And that gives rise to, as I think Steve articulated well, a call for thinking about applying the OIRA review process to the so-called independent agencies. But there's another approach that I think is something that can go beyond this. Either what we have right now is no requirements for regulatory analysis before the so-called independents adopt rules, or the full OIRA review. And if we look at another option, it would be, and one thing I would say about this option, by the way, is that we've been living with the world with no requirements, really, and presidents, notwithstanding recommendations from organizations like ACUS and good scholarship that suggests presidents could indeed subject independent agencies to an OIRA-like review process. It hasn't happened. I think a way of thinking about something beyond the all or nothing would be to take a modest step, a semi-step, if you will, toward requiring agencies that are defined as independent under the Paperwork Reduction Act to the requirements of the Unfunded Mandates Reform Act, which is a statute that requires agencies to conduct benefit cost analysis before issuing rules that will impose significant costs on the private sector. The advantage of this approach of withdrawing the exemption that's in UMRA, the Unfunded Mandates Reform Act, for the so-called independent agencies is that it removes any excuse that independent agencies might have for not doing this kind of regulatory analysis, but it doesn't go all the way to subjecting them to White House scrutiny, which would, I think as Steve acknowledged, be a big change in our prevailing norms and practices in the federal government. So I think recognizing the semi-autonomous nature of the administrative state is important both descriptively, it does better describe what's going on at both executive and so-called independent agencies, but it is also something that can help us break free of binary distinctions with respect to policy interventions, get beyond an all-or-nothing approach with respect to regulatory analysis, and impose the requirement that is judicially enforceable under UMRA that agencies conduct better analysis, and in that way strike a better balance between insulation and the kind of accountability that comes from good regulatory analysis. Thank you.
Thank you. Professor Dudley.
Thank you, Judge. Am I on?
You are.
So I'm very interested in this panel and very happy to be here. When I was asked to think about what I would say, the first I came to mind was Hamilton's "If men were angels" quote. So I think, as several people have mentioned, presidents have recognized that their appointees are not angels. And so for almost 4 decades, they've tried to exert some accountability and control over the regulatory process through the OIRA review that Steve talked a lot about, and through the requirement to conduct regulatory impact analysis of proposed rules. So this is bipartisan. Just a couple months ago, we celebrated the 25th anniversary of Executive Order 12866, which President Clinton signed, and which is still in place today. And what it does is it tells agencies first to identify the compelling public need that requires a government solution. This, for those of you who were enjoying the fire hose talk yesterday morning from Richard Epstein, he talked a lot about we first have to, when markets work, let's leave them alone. But if there's a market failure, that's a compelling public need. And that's something that presidents have directed, as the judge said, since 1981, and actually even before. And then once you've identified that need, then analyze the benefits and costs of alternatives, including the alternative of not regulating. That's specifically in the order. And third, choose among those alternatives the one that maximizes net benefits. So this is what Steve was talking about, that test. So why is it not enough? And I think I'm answering Judge Brennan's third question. Why is that analysis not enough? In an article, forthcoming article in the UVA Journal of Law and Politics, Ryan Mannix and I identify both institutional and technical explanations. So I'm going to quickly try to go through those. On the institutional barriers, the first is that executive orders are limited to the extent permitted by law. And often Congress, in writing the statutes that give agencies regulatory authority, do not, they pass laws that are silent on benefit cost analysis. And as the judge mentioned, agencies tend to interpret that silence as prohibiting benefit cost analysis. In some cases, like American Trucking, the Supreme Court has agreed with them. But more recently, courts are finding that not only are agencies not prohibited from considering costs and benefits, but that it may be arbitrary not to consider costs. Michigan v. EPA, that was an important decision. The second institutional barrier is that it's the agencies themselves that conduct the analysis. And it often looks more like an advocacy tool than a transparent accounting of the alternatives available. These regulatory impact analyses can be dense and complex, possibly deliberately so. They can run into the thousands of pages. And they often seem to be done after the fact to justify a decision rather than in advance to evaluate different alternatives. Third, efforts to counter agencies' parochial perspectives, such as oversight and public comment, haven't been fully effective. Except for the Congressional Review Act last year, Congress oversight of regulation really is pretty weak. OIRA, I think, is a very important office, obviously, since I worked there as a young economist and was the head of it more recently, but it's a very small office, and as we've heard from both Cary and Steve, not all rules and not all agencies, independent agencies in particular, are subject to those requirements. Public input, public comment is important. Yesterday morning, Professor John Michaels said that public comment was the equivalent of Congress providing oversight within the executive branch. But it comes very late in the process, often too late to change the policy direction. And courts do provide checks, but as I said, compliance with the executive orders isn't judicially reviewable. And I think we'll hear more from Katherine about deference that courts provide to the agencies. And then my fourth and final institutional constraint is that the government rarely looks back to evaluate their regulations after they're in place. So the analyses that they do, these 1,000-page analyses, are essentially hypotheses of what the world will look like after we've implemented a regulatory solution, but we rarely go back to test that hypothesis, so you're missing that feedback loop. Agencies do not have the incentives. They're not required to. Like, you have to do that ex-ante analysis or OIRA won't clear your rule. But after the rule is in place, it's not that much fun to go back and look at an old rule. It's way more fun to think about what the next problem is to solve. And it's not just the agencies, but regulated parties as well often are not as interested in evaluation, review of rules. Once they've complied, they may even put up a competitive barrier to others who might want to enter the business, and so they also are not always interested in retrospective review. Sorry, I'm getting a cold, I think. So now to the technical barriers. And this, I think, really is starting to answer Judge Brennan's third question. I think the way benefit cost analysis is applied may systematically bias its results. First, agencies don't start by identifying that compelling need for the government intervention. So they often start with a presumption that economic markets are fragile and prone to failure, but that regulatory solutions will work exactly as planned, and that regulated parties, private decision makers, are subject to all kinds of cognitive biases that somehow the regulators themselves don't share. Second, they often don't approach benefits and costs in an objective manner. A large percent of the total benefits, OMB every year tallies up agencies' estimates of the total benefits and total costs of regulations issued over the last decade, and more than 80% of those benefits come from what are known as co-benefits, which means they're serendipitous side effects of a regulatory action that is achieving a statutory goal. Sometimes analyses seem to search for every possible co-benefit without looking to see are there also indirect costs or unintended costs. In fact, the word co-cost is never used in an agency analysis. There are people who think you should never use co-benefits. I think my perspective is different. It's more that you need to be balanced when you're doing that analysis. Third, the underlying risk assessments, the science Cary mentioned, the importance of the science, and I agree, that goes into a lot of these decisions. But the way it's done is incompatible with benefit cost analysis. The practice in estimating public health and environmental risks is to err on the side of safety versus providing an objective estimate. So that approach not only hides uncertainty in the estimate, but it deliberately overstates risk, which unintentionally will misdirect resources that raises costs, but it also may be making public health worse if you're biasing, purposefully overstating some risks and not others. And then finally, I said before, retrospective analysis is very important, but not only are the incentives not there, but it's really hard to do. You don't know what the counterfactual was. Once a regulation is in place, what would the world have looked like without it? What are the opportunity costs? What unseen inventions and benefits did we not get because we took a particular path? So let me offer a few solutions to both these institutional and technical problems. Institutionally, I think independent agencies should be subject to OIR review, and I expect we'll have some more discussion on that. I would like to see Congress pass legislation that codifies these executive orders, bipartisan executive orders that require that analysis. I think legislation could provide for judicial review. We need more vigorous and meaningful public input earlier in the process. I'd love to talk more about that if you're interested. I think it would be great if agencies could be required to, before they issue a new regulation, evaluate whether their last regulation addressing that problem, evaluate how that worked. And then finally, a regulatory budget. Steve mentioned President Trump's executive orders requiring costs to be offset. That can counteract some of those institutional incentives that I talked about. On the technical side, if I were king, I would require agencies to consider how the regulation will affect competition. That should be an important part, is recognizing that competition can sometimes be a better regulator than government action. Recognize that behavioral insights apply to regulators as well as those being regulated. Examine benefits and costs in a consistent manner. Provide expected values when doing this underlying science and the estimates of risk, and ranges based on probabilistic analysis rather than precaution. And then finally, to design regulations to facilitate natural experimentation and learning. Yesterday, there was a lot of talk about federalism, and I think that's a great way to address that. So bottom line, and I may be going over my time, but when collective action is necessary, benefit cost analysis is a valuable tool for informing policy decisions, but it's not a replacement for the market process, which is dynamic and responsive to diverse preferences and changing conditions. It's necessarily a static exercise, and it depends on assumptions and models about how the world would look in the future with and without a regulation. Those assumptions are often highly uncertain and not transparent to decision makers or the public. So if we could address both these institutional and these technical barriers that I've talked about, I think we might better balance the concerns of this panel: agency, insulation, and accountability.
Thank you, Professor. Professor Sharkey.
Thank you. Good morning. It's a real privilege to be here this morning, and I'm still thinking over Dean Reuter's story of the snow, and I'm thinking about my experience getting here from New York last night. And Steve, I wonder if NHTSA has some rules that might help. I'm typically sensitive to federalism concerns and leaving local and states to handle local problems, but Manhattan was kind of in a complete shutdown with externalities going well beyond just the transportation system. So I wonder if NHTSA has some rules that could have helped us.
You want NHTSA to fix Manhattan? That ain't gonna happen, sorry.
I'm wondering, as you'll see in my remarks, I'm quite interested in thinking about various both institutional design questions and features, like what I'm going to talk about today is judicial review in a kind of information forcing, incentive forcing framework. So maybe NHTSA could come up with something that would have a good local incentivizing effect on transportation in the city. So I want to talk about a few things briefly. So the first, I want to go back, and it's going to seem a little bit self-referential, but in 2014, I wrote a law review article with what I thought had a catchy title, but I've been castigated for it, called State Farm with Teeth. And then it's called Heightened Judicial Review in the Absence of Executive Oversight. And notwithstanding that I got lots of mockery about defanging State Farm, et cetera. Maybe it's because I'm Sharkey. I'm sticking with the teeth metaphor there. But the premise of that article, it actually used, I was inspired to write it by the Business Roundtable decision, the DC Circuit decision by Judge Ginsburg that struck down the proxy access rule, the first SEC rule coming out of Dodd-Frank. And I was intrigued because there was a lot of controversy over that opinion, lots of people focusing about whether the proxy access rule was good or bad, et cetera. And what I was intrigued by was it looked to me like it was a use of this judicial doctrine, State Farm, that's supposed to be interrogating, as Cary alluded, to the making sure that there's reasonableness and reasons giving in the underlying agency rule. And to my mind, it suggested an interesting scheme whereby courts might use sort of what I was calling this heightened judicial scrutiny, State Farm with teeth, particularly in instances, this being the SEC, an independent agency that did not subject this rule to OIRA cost-benefit analysis, that it might be an added justification for more heightened judicial scrutiny. And I was not only interested in making that claim, but also thinking about what the incentive effects would be on the agency. So the article goes through and looks at how some of the federal, particularly banking regulatory agencies, decided to take some action sort of in the shadow of that ruling, beefing up their internal departments that were engaging in cost-benefit analysis, certain agencies like the CFTC going and having a memorandum of understanding with OIRA that wasn't subjecting it legally to that structure, but was actually seeking to do the kind of rigorous analysis. And I guess I was playing in that article with from the agency's incentive perspective, a kind of possibly Faustian bargain, right? They could choose their poison, executive oversight or more heightened judicial scrutiny. And I was intrigued by that concept. I think all of us are coming back to this notion of what does it mean to have reasonable regulations. And just as a footnote, in addition to being an administrative law person, I teach tort law, and I don't understand actually in the academy why more people who are interested in health and safety regulations and the like don't bridge sort of the private tort law perspective with the public administrative law perspective. My colleague Richard Epstein certainly does. I unfortunately missed his fire hose, but he's my colleague, and I'm a co-author now in his casebook, so I think I can imagine a few of the things and his perspectives of what he had said yesterday. But I want to, for the moment, just say what I think he has a particularly interesting perspective, and one that's not shared by, I think, enough academics about understanding which types of things private law and markets, et cetera, can handle, and where you need the kind of public regulatory sphere. But my point here to bring up tort law is, of course, obsessed with reasonableness, and we have all these different tests for how can we give some kind of content to it, and the economists like the hand formula, which, of course, is a cost-benefit kind of formula, and there's a lot of similar kinds of talks with how judges can come up with standards that would maybe help us from this perspective, coming up with better types of rules. And so I guess I share that kind of framework. And I think that judicial review, well, it's not necessarily a panacea, it's not going to solve all of the problems, can be helpful there. So after writing that article, of course, everyone was waiting with bated breath for the sequel. This is what law professors like to think. And so the sequel has come out. So don't worry if you missed the original. So this, because the sequel kind of recaps a bit. The sequel that I've written is called Cutting In on the Chevron Two-Step. And so the most recent article, it's in Fordham 2018. So it took me, 4 years. Every 4 years, I guess it's like, I don't know how often Star Wars came out when it was coming out with the sequels. But this article tries to actually make the point that while State Farm has been thought of as this doctrine really interrogating the policy analysis of agency regulations, and Chevron has really been thought of as a deference doctrine when agencies are interpreting statutes. This article tries to suggest that the policy interrogation and the statutory interpretation perspective should be merged. So the cutting in on the Chevron two-step, as you've probably, it doesn't take a lot to figure out. I want State Farm to cut in at Chevron step 2. And I think that this would be a good development. I trace in the article, for example, there was a case coming out of the Second Circuit called Catskill Mountains. I use that as a kind of showpiece because the district court in that case, it had to do with the water transfers rule, and which was a rule by the EPA about whether it needed permitting when water was being transferred. Actually, Cary, you brought up this like water with the murky banks, and of course I was thinking about what are the social economic effects if this water is getting murky in one and transferred to another basin, because this is what's at issue with the water transfers rule. And the district court did an interesting thing in that case and basically said that the EPA, when it came forward with its rule that through the water transfers rule that it didn't require permitting, hadn't provided any of the underlying empirical evidence. And it was just really a legal analysis that the agency had given to justify what it was doing, and so it was rejecting it on that ground. This gets overturned by the Second Circuit, and it was the cleanest example I could find. I actually came up with lots of examples where I was having to force this analysis onto whether courts of appeals were or were not doing State Farm policy level review, because of course in the DC Circuit, a kind of typical framework is they'll do Chevron step 1 and step 2, and then get to State Farm review and do it as a kind of step 3. In some jurisdictions, they'll do State Farm as a kind of step 1 and then get to Chevron. But this was the cleanest example that showed how it might matter. It might be outcome determinative, because the Second Circuit overturned the district court saying, boy, that's too much judicial scrutiny at step 2 of Chevron. Once you get past Chevron step 1, where you say that this statute is ambiguous and we're therefore going to look to whether what the agency doing is quote unquote reasonable, that's too much scrutiny, and we don't want to import State Farm level scrutiny at that step. And I think that's actually exactly wrong. I think that the worry, if you don't do that, is that agencies might be incentivized to use quote unquote what I call sort of legal or step 1 type analysis, namely agencies would be using all of the kinds of statutory interpretation, legal arguments, the text of the statute, if it's allowed, legislative history, purpose of the statute, et cetera, and they would use those arguments, the same arguments that they're using to say this statute is ambiguous, and once they get past that level, so that A, B, or C would be a reasonable, possibly, interpretation of that statute, at step 2, they do nothing more. They just default back to their legal analysis. We think B is the right legal answer. And what I would like to happen at step 2 instead is that the agency would have to put forward their scientific empirical evidence for their policy preference for B over A and C. And if it doesn't come in, and the courts don't interrogate that, I think that the agencies wouldn't be incentivized to do that. So that's what I did in that. Now I know some of you are like at the edge of the seat. What's the third going to be? Or I'll pretend so that I can give some kind of normative justification for gathering at this hour of the morning. I've become really intrigued at thinking about what is going on at the state level, right? Because I've so far done a lot of looking at how the federal courts, and in particular the courts of appeals, might harness this kind of Chevron, this Chevron/State Farm framework. Before I get to the states, one other interesting point, I think. One of the other reasons importing State Farm into the Chevron two-step is really important is when these issues come up in cases involving private parties. So the idea is that when private parties have litigation and the agency isn't a party to that case, there's actually some really interesting things that go on in terms of courts giving what I think is too much deference to an agency position that hasn't been interrogated. And so this importation of State Farm into the Chevron framework will allow for that level of review to happen, right, where the parties wouldn't be able to bring a direct State Farm kind of challenge right there. So it's an indirect way of challenging some agency actions. And I have, in some previous work, I've talked about how federal preemption cases give us a really good lens into looking at this. Namely, we have private parties, an injured plaintiff is suing a manufacturer of a drug, et cetera, but what's at issue is what the FDA thought in terms of how much of a rigorous review it did of the particular drug label, let's say, or what have you. And this kind of state farm into Chevron analysis, I think, allows for a good doctrinal framework for courts to be interrogating the underlying basis for the agency's judgment and perspective, even when the agency's not before it. And we can talk some more about that if you're interested. But the third in this series, if I get around to writing it, and anyone other than my family is wondering when the next Star Wars is coming out, has to do with looking at the states. And of course, this is an interesting year to be thinking about that. There's some recent commentary that has suggested that this is the year of the Chevron revolt, and there's some interesting things happening at the state level. Just very recently, we saw in Florida, there was an amendment passed to the Constitution that would be, that is doing away with Chevron. Arizona amended their state procedural rules. I'm at the beginnings of looking. It's actually very fascinating that there's a wide array of state practices going from the throw Chevron out the window to maximal deference, no judicial scrutiny, no interrogation. I'm, for obvious reasons, very intrigued with states that are kind of in the messy middle. Here I have to allude to Richard Epstein always says, I'm searching for the Aristotelian golden mean, but it's usually a bad, endeavor in the kinds of issues I'm thinking about. So I guess he's right here too, at least that I'm searching for the Aristotelian golden mean. I think embedded, it's a little difficult because the state court analyses look a little different from the federal court analyses of these issues, but there are some states so far I've identified who are my Kansas and Idaho in this kind of intermediate space where they seem to be embracing a kind of Skidmore power to persuade type standard as opposed to the Chevron standard, but allowing for the possibility that there could be some judicial scrutiny of the underlying scientific and empirical basis of a kind of agency regulation. So I'm very intrigued with trying to think about if this might be a good approach. It obviously is, in my mind, a kind of Aristotelian golden mean because I'm not ready to embrace the throw Chevron out the window approach, although we could talk about that in Q&A, et cetera. So I think I will end there. Again, I'm really excited about being on this particular panel with colleagues who have thought a lot about various aspects of this area of the law, and I look forward to your questions as well. Thank you.
So thank you to the panelists. We've heard a call for large change. We've heard a call for more modest step. We've also heard discussion of both institutional restraints and technical barriers with some proposed solutions. And then finally, some discussion of a proposal with regard to judicial review and the doctrinal framework that these circumstances are analyzed under. This is the part of the program where the commentators will have a chance to comment on each other. And so I'll turn it over to the panel and see if there are certain responses or observations that anyone might have on each other's comments. Steve.
Can I jump in?
You may.
Thanks, Judge. I want to disagree with Cary here on the discussion of autonomy, agency autonomy, in a couple of respects. First, I do think that the distinction between an agency that we recognize as fully within the executive branch and under the management, control, and supervision of the president fully, and a commission or multi-member agency that we refer to as an independent regulatory agency, I do believe that distinction really is binary. And I do think it turns on the for-cause removal restrictions that Congress by statute puts in place for those, the removal of the heads of those agencies or members, which insulates them from full presidential supervision and control. I think that in the real world, inside government, that's a critical distinction. where the agency head serves at the pleasure of the president and is fully part of the president's policy and management team. The agency head and everybody who works for the agency head knows that when the White House calls and there's an issue of concern to the White House and something the president is focused on as an initiative or a priority, you really do need to attend to that, and you do need to participate in the president's discussion of those issues and respond to input from the White House and the president and other agencies of the executive branch. And if you don't, it can be a immediate action the president takes to remove the agency head. Now, that doesn't happen every day, and there is a political cost to that for a president, but it's an enormous leverage in terms of management control and supervision. It really is the key instrument the president has to ensure reasonable actions and efficient actions across the executive branch. And for-cause removal restrictions are interpreted to impose real limits on that ability of the president to remove the agency head, and they are interpreted to impose some due process requirement in terms of notice to the agency head, some causes, some reasons given, and opportunity to respond, et cetera. And courts have upheld that in terms of agency heads who've been removed, seeking reinstatement, et cetera. And it does create a real world insulation and distance. So I do think that's the critical distinction, and it is largely a binary one. In terms of autonomy, I think with autonomy, there is a greater risk, actually, that of regulatory capture with agencies. They have the tendency to be more responsive to the industries and actors that they regulate than to a unitary view from the top down in the executive branch as to what is the right approach on issues, and also a greater risk of congressional interference and sort of micromanagement or management of the actions of the agency. And those tendencies can really undermine the effectiveness of the unified executive. I mean, we only have 3 branches of government under our Constitution. The executive branch is under the supervision of the president. To the extent agencies are actually autonomous and independent of that supervision, they are less accountable to the political will of the citizens, and that is a real danger. Lastly, I'd say Congress can achieve a modicum of real autonomy by specifying in statute what factors and what technical requirements, et cetera, the agency head needs to address in any particular regulatory action. Congress, by statute, can place the authority to make the decision in the agency head. It's not the president's, it's the agency head created by statute. And Congress can specify specifically what information and factors that decision must be based on. The president can't override that. The president can supervise the exercise of that authority, but it does reside with the agency head, and it must be based on the statutory factors. That can achieve a degree of autonomy that I think addresses the institutional concerns that Cary raised. So, thank you.
Cary, floor is yours.
Yeah, I don't disagree with most of what you said, Steve. I have a paper called The Emptiness of Decisional Limits. So on the last point, for example, I think it is very clear that, you know, statutory authority delegated to an administrator must be exercised ultimately by that administrator, but there's lots of opportunities for presidents as a practical matter to shape and direct that. And I think, quite frankly, that happens with the so-called independent agencies as well. It was hardly a surprise in the last administration when the Federal Communications Commission seemed gridlocked on the net neutrality rule that after President Obama gave an address calling for the net neutrality rule, that's what was enacted. But also, it is not a surprise that a new administration comes in and puts in place a new chair of the Federal Communications Commission, and the net neutrality rule disappears. So I think certainly as a formal matter, we can say that there are 19 agencies listed in the Paperwork Reduction Act that are defined as independent agencies, and we can look and say there are agencies that have for-cause protections and some that don't. But I think what that means at an operational level is much murkier and less clear-cut than a binary distinction would mean. Again, the Revesz and Detla paper does a nice job of showing that even with respect to for-cause protections, there's different language. There's also some agencies that have independent litigating authority and others that don't. There's some, like the Federal Reserve or the Food and Drug Administration, that have some non-appropriation sources of funding. So there are ultimately different formal structures that break down even a formal binary distinction. But what I want to suggest is we need to think about what this means at an operational level, and it's at that level that I think it's really a continuum. There are some agencies that, as a practical matter, are harder for presidents, even presidents that can remove at will from directing, then there are others. And that is ultimately, I think, the direction to go in, is to think about not just these formal structures, but think about, well, what is actually the problem with respect to too much autonomy. With respect to the regulatory analysis front, I certainly get that, and I think that's fixable by amending UMRA rather than going ahead and extending the executive order.
Susan or Katherine, do you have comments on that?
Maybe this is a question for other panelists. One of the things you said up front, Judge, was does the question of an agency's independence depend on its mission, and do we care? So are there any things, I wonder, that Steve would say maybe that should be more independent than others? Now, yesterday we heard, there was a panel on independent agencies, and we heard from Henry Kerner, who is the special counsel in the Office of Special Counsel, which I learned yesterday has nothing to do with that other special counsel that's been in the news.
It's the special counsel.
He is the special counsel, he said. And it was pretty clear to me that maybe that shouldn't be covered. But then again, it's not regulatory. The Federal Reserve is another one that does issue some regulations, I wonder. So I wonder, maybe Steve, Cary, Katherine, do you think there are some agencies that should be completely independent, maybe not even subject to UMRA?
Well, I will say that Congress, as I indicated, Congress by statute could identify certain decisions, certain types of exercises of government power that Congress has determined should be made on the basis of certain considerations, and can ensure that the integrity of that decision is maintained, and that the public can have confidence in the reliability of it, because it is focused on those types of factual, technical, scientific determinations, for example. That kind of statutory specification, to that extent, insulates or is designed, I think, appropriately to insulate that decision from other considerations that maybe are viewed as not legitimate for that particular exercise of authority. In addition, we, of course, have important due process principles when it comes to an enforcement action against an individual employee of the government, for example, for corruption, violation of statutory restrictions like the Hatch Act, or an agency for discriminating in the hiring of employees or promotion. Those are the kinds of issues, enforcement matters, that the Office of Special Counsel is empowered to enforce, and we want to protect the due process rights of the individuals who are the subject of those actions, and also of the integrity and reliability and public confidence in the decision making that's done. And so it's appropriate to treat them as outside the maybe political influence and management influence of the president. But the ultimate goal is accountability for government action and confidence that the public has in government action. And I think the Constitution recognizes that the primary channel for achieving, maximizing political accountability and confidence in executive actions is by concentrating management and supervisory authority in a single person, the President of the United States, who is, along with the Vice President, the only officer of the United States who's elected by the entire country.
So I would, this is a fascinating discussion, and I guess there are just two aspects or dimensions that I'd like to put on the table as well. So first, as I alluded to quite quickly, but I'm quite intrigued, Cary mentioned that for a long time there's been this debate about subjecting independent agencies to OIRA review. There's actually some really good work. He alluded to my colleague Ricky Rivez and Curtly Datlai's work about blurring distinction between these. I'm intrigued by this idea of agencies voluntarily submitting to OIRA and having appropriate incentives. As I mentioned before, maybe judicial review would incentivize the threat of heightened judicial scrutiny might incentivize that more, and that would be a kind of other sort of proposal that I think would be interesting to talk about. And then the second dimension to that is I think increasingly agencies are working together, doing joint rulemaking, and we have independent agencies, so-called, working with executive branch agencies, and this raises really intriguing judicial deference type questions. So the DC Circuit has kind of this strain in their doctrine that if you're dealing with more than one agency, then none of them would get Chevron deference. And it seems like that might not be the exact right solution to that, but I don't think a lot of thought is being placed into what kind of deference will be given in these kinds of increasing, I think, terrain where we have multiple agencies acting together.
Susan, one of the things that you've written about is the Independent Agency Regulatory Analysis Act of 2017, which was a submission, I believe it's in bill form at the moment, for regulations that would have an annual economic impact of $100 million or more. OIRA would not have the power to reject the rule, but they would certainly do that kind of analysis. Perhaps you could give us a little bit of your thoughts on that bill and the status of it.
Okay, yeah. So I'm curious about Cary's suggestion of using the unfunded mandates, and maybe I'll get too much into the weeds if I ask him questions about that. So right now, OIRA reviews the information collections of independent agencies under the Paperwork Reduction Act. And the way that they do that, and I think this is a model for maybe having OIRA review independent agencies' regulations as well. The way they do that is that they review the information collection, give the agency feedback, and they can disapprove that collection the way you might disapprove a rule, but the commission, a vote of the commission can override that. So to me, that strikes a good balance, that it keeps that commission, has some independence, and can override OIRA's review, but it does add that additional accountability that I think can be valuable. I just want to respond to Steve a little bit. I'm concerned a little bit about the notion that, well, Congress can specify in statutes, and they do, but that is often part of the problem, is that they'll say in a statute and tell their constituents, we are issuing the statute to protect public health with an adequate margin of safety. And that's what the statutory language says. And then when the agencies interpret that, and the courts do, as, well, that means you can't consider trade-offs about how much it's going to cost to achieve that. Congress can then take credit again by holding hearings and exclaiming how awful the agencies are. So to me, saying, well, we can get around this by letting Congress pass statutes, they tend to do it in a way that allows them to shirk responsibility, set high-minded goals in their statutes, and then leave to the agencies the difficult parts, which when they don't work, which they won't, then Congress gets another opportunity to be high-minded.
Could I pile on that just a little bit? Because I want to bring up the example of the Motor Vehicle Safety Act, right? So this is something I've thought a lot about too in the preemption realm, where there's this strong view that like agencies shouldn't be giving any input whatsoever to courts. Think about the Geyer case, right, where the court said they're going to give some weight to what NHTSA thought, in that, there are some individuals who have the view, agencies need to be entirely out of this. They aren't the right entity to be doing this. Congress has to specify clearly in statutes. Well, the Motor Vehicle Safety Act is not uncommon in the realm of products liability kind of spheres, where Congress will either speak out of both sides of its mouth, right, have a preemption provision and a savings clause, and it's over time, as preemption has been put before Congress in a variety of realms of different areas. Congress never clearly, or very, very rarely, will clearly articulate what the effect of a federal rule or regulation should be on state tort law. And so one might think that Congress actually, is affirmatively punting to another institution, and maybe is affirmatively punting to an agency to be able to inform some of these kinds of decisions.
Steve?
May I respond? Thank you. I think what I was trying to describe is something that's very different, and maybe the opposite of what your concern is, Susan, that you raised. I think you're talking about a statute that does not at all specify the particular factors and technical facts or considerations that the agency needs to limit its review to or its consideration of in making a decision, but rather has a very broad amorphous standard, like achieve public safety or advance public safety based on actions in the public interest. So that's not an uncommon type of very broad delegation of regulatory authority, which I think leaves the president a very broad scope of supervisory, to exercise his supervisory authority based on a wide range of public interest related factors, economics, how markets work, the practical and feasibility implications of decisions, and really there's a wide compass there. And I was suggesting that Congress could exercise more judgment and specificity in directing a particular regulatory delegation if Congress did that, those factors would be factors that, as a statutory matter, the agency would need to focus on. I think it's kind of consistent with the concern you raised that a more specified or specific exercise of legislative judgment would be an effective way for Congress to go. May I say something about judicial review, which is obviously critical, important to the process, but the judiciary is not part of the executive branch. And I always view that Chevron and deference standards like Chevron are standards that are addressed to the court and help to frame the role of the court in reviewing an executive action, a regulatory act, an administrative action by an agency. And as a general counsel of a department, I don't actually view Chevron as the roadmap for how the agency should exercise its substantive authority in an area. I still think the agency should do the right thing, should make the best judgment, should apply the statute in the most faithful way, and should take into account the practical implications, the economics of the markets involved, the need for the regulation, and should try to ensure, unless a statute clearly and expressly says otherwise, that the benefits, the measurable benefits of that proposed regulation outweigh the costs and continue to do so after the fact. I mean, there should be periodic reviews of that regulation. And it's not just a matter of what can we get away with in the courts. What will, is there an argument that this statute is ambiguous, and is there a good chance that a court will let us get away with this particular interpretation because it's within some broad range of reasonableness under the statute? I don't really think the Chevron framework should dictate or should guide how the agency exercises its authority, but it is an important restriction on the role of a court in terms of not replacing the technical subject matter judgment of the agency in exercising the authority delegated to it by Congress under the supervision of the President with the court's judgment as to what the better answer is, because the court is not accountable to the public, is not politically accountable, because judges have life tenure and their salaries cannot be reduced during their service. So critically important that courts play the proper role under our system that they should play, consistent with their judicial function, and that the executive branch under the President's supervision has the authorities delegated by Congress to make those subject matter judgments in exercising statutory authority.
Cary, do you have thoughts on that?
Yeah, just want to pick up a little bit on what Steve was just saying, and again emphasize how I think that's exactly the reason why all agencies need some level of autonomy. A semi-autonomous agency is one that is not being over micromanaged by the judiciary, for one, but it's also an agency that has the space and the degree of autonomy that's needed to make that good faith determination of what the statute calls for them to do, what the evidence says, and I think it's why all agencies, again, should have some degree of autonomy in that sense that it allows them to do the kind of analysis that's required to advance the public interest. Now, Susan, I think you certainly called attention to some of the political economy phenomena with Congress and delegating authority and trying to kind of claim credit for solving a problem at a very high level of abstraction, and then also being able to blame the agency again when something goes wrong. And that's certainly a concern. I see that more as a concern with delegation in general, and I think that it's possible for Congress to do that with respect to an agency that has an administrator that's headed with for-cause protection or not, right? I think if we're talking about sort of insulation in the sense of a formal structure or a degree of autonomy, which agencies should have more autonomy than others, then, I mean, I don't know if this exactly was your point, Steve. I do think that Congress can make that decision. Too. That's certainly something that can go into how Congress decides to structure the agency. Again, with all caveats that those structures don't necessarily always equate with at an operational or decisional level with real autonomy. But it's also from a policy standpoint, I think your question there raises, well, what are those decisions that should be made more on the basis of a fair assessment of the benefits and the costs, and the co-benefits and the co-costs, right? And to get to that kind of vision of an administrative state where there's expertise that's being pursued in good faith and in a balanced, neutral, nonpartisan manner, that too will require more autonomy, I would say, than less autonomy.
Susan?
And I'm concerned about that, and it gets back. If the experts in the administrative state were angels, I would agree with you. But the political economy points, I think, apply there too. Their incentives are to, to grow their area of responsibility. They're drawn to an agency because they care more about that issue than other issues. And so, in my experience, if you're in an agency, you tend to think that the problems that you're trying to address are more important than any other problems, and therefore we should spend a lot of society's resources to address those. I think we can't trust, I think the autonomy troubles me because we can't assume that they're going to be acting in the best interests of the public at large. There's a principal agent problem unless there are these institutional constraints, and that's why I think we need to think more about how to constrain them so that we can trust the decisions that they make. And the way I would start would be the way Richard Epstein was saying yesterday. First, let's not regulate unless you've identified a clearly compelling public need, a material failure of private market. So that's language from the executive order. And if we start there, then at least that's one area of things that those experts who probably have the tunnel vision that Justice Breyer talked about maybe can't get too carried away.
Well, there are non-angels floating around all around, right? Whether it's in the bureaucracy or in the Congress or in the White House or in OIRA. Let's be.
OIRA's all angels.
Let's just
law schools too.
In the academy, you bet. This is why I think actually the UMRA would be the better first step, at least, because quite frankly, there hasn't been an administration that's yet taken on the full step to applying the executive order and its market failure requirement to the so-called independent agencies. And there's a lot of reasons why it would be hard to apply that. I mean, just in terms of the resources and the like as well that would need to be devoted to, increasing the staffing at OIRA and so forth. But if we got rid of that exemption in UMRA, then there's a requirement for a statement in UMRA that is very similar to the market failure test. And it seems to me that if you've got a statute that's requiring, and this is Congress, by the way, so we don't get into any of the issues about president interfering too much with these, agencies that are so-called independent, right? We wouldn't, if we just amended UMRA, it'd be very clear. It would also be very clear if Congress passed the kind of independent agency legislation that you're calling for too, and I think you're right that the kind of up or down approval or disapproval is another way of making that work. I just think that this would at least provide every agency a requirement to do some consideration of what the benefits and the costs are of a rule.
And for those who are looking for further study, that Unfunded Mandates Reform Act is at 2 U.S.C. 1501, where you can review some of the provisions that Cary's been mentioning. We are going to move shortly to questions from the audience. Before we do, though, I want to recognize the panel if there's any other comments that they'd like to make beforehand. Katherine?
Yeah, just Steve, your perspective was very welcome. It was interesting, particularly when you said, within the agency, it's not as if rulemaking is proceeding, kind of, I think you said sort of how to evade various requirements with Chevron in mind. But I guess what I'm interested in, you didn't mention whether State Farm and State Farm type review could incentivize agencies in a particular way. And again, I guess the example that I have in mind is it's not a NHTSA example, or the one where you say, the agency is going to be focused on the impacts and the empirical evidence. But in Catskill Mountains, what the EPA did in their rulemaking was specifically use what I'll call legal arguments, right, that would come in at Chevron step 1 and say, we don't have to actually vet the impacts, the economic effects, et cetera, of that. And that's what I worry about, that it does, I mean, it's back to your angels point, but it's if Chevron is supposed to be giving deference for policy analysis by the agency, but instead it becomes a way where their legal analysis is deferred to, that doesn't seem, that doesn't seem right to me. So I was just curious your thoughts there.
Well, State Farm, which basically said agency decisions may not be arbitrary and capricious. Agencies need to consider the material relevant factors and acknowledge and address significant comments received from interested parties, and the decision making must be reasoned and reflect a reasonable process. I think that is an appropriate statement of a standard that does apply to the agency, and it is a judge-made encapsulation of a standard that is one that should guide the agency in all decisions as part of a regulatory process. So, yeah, I do think that's fundamental, and I guess I would also just add that in terms of the men are not angels concern, I think the concern that agencies with a delegation of very significant, sometimes very significant regulatory power from Congress that may have the tendency to think this regulatory proposal is the most important one, and we have policy objectives that, in our view, override economic considerations or some practical considerations that may be flowing from the proposal, is exactly why I think it's critically important for significant agency rulemaking proposals to go through the interagency process and to have the more independent and sort of technical expertise of the OIRA staff review a proposal and to subject it to an interagency review and comment process within the government as a tool for the president to ensure the more efficient supervision of that exercise of authority, precisely because sometimes the outposts within the executive branch tend to get caught up in their own field of responsibility and what their objectives are. And the interagency review process, the OIRA cost-benefit assessment process, helps to ensure consistency and that some of these major proposals are seen in light of how they impact what other agencies are doing and the overall sort of costs and benefits of the executive branch functions and actions. And so that's exactly why it's a tool that helps ensure and improve political accountability and helps address the kinds of risks that I think could come into play to the extent that the agencies are more autonomous and separated from that consistent, unified review and management process that the president can carry out. Thanks.
Thank you. I trust, obviously, these comments have engendered a lot of questions from our audience, so you should obviously feel free to line up at the microphone. 3 requirements, though, as we go forward. First, please give us your name and affiliation. Secondly, I'll exercise the moderator prerogative that if it's a long preface, we need to move from a declarative sentence to an interrogative sentence at some juncture. And third, if there's a particular speaker to whom you are addressing the question, try to fold that into the beginning of your remarks, or if it's to the entire panel, let us know. Let's start with the first microphone.
I'm Kai Alberg from the state of Washington. And my question is directed more at state-level agencies. In our state, we have a Department of Ecology that issued a rule that shut down building in large parts of the state to protect the salmon. And to justify that, they had a cost-benefit analysis where they said each salmon is worth $5,000, And if we don't issue this rule, we'll be sued by environmental organizations, which will cost us $50 million. Therefore, given these costs, the benefits outweigh, we have to issue the rule. Judges don't want to touch these numbers because they're factual and they give deference to the agency. How can one correct such abuse, I would call it, without just getting rid of the agency?
Katherine, do you want to take that one? Or?
Yeah, so I do think that numbers, I don't know where did the gentleman go? Oh, there you are, sorry. I do think that numbers can be challenged. So I think you're right. I mean, to just broaden your question a bit, there's a way in which, and this came up in the proxy access rule that was the subject of Business Roundtable, it's not as if all the weight of the evidence is on one side. There are competing empirical studies, facts are complicated, science is complicated, but the court was able, and of course Judge Ginsburg said, well, this is because the DC Circuit is like an administrative law court with the expertise to do this. So I recognize you might have some judicial competency, institutional concerns about the ability of judges to interrogate this, but I actually think parties can challenge the underlying facts, science, et cetera, and that should happen, and then the court is able to review that. So I don't think it means that you have to abolish the agency. I do think, though, that it matters. So it's kind of a case example I'd love to look into, because I don't think, you said apart from kind of abolishing the agency or throwing Chevron out the window kind of approach, I do think there's some problems in state court jurisdictions that are giving mandatory Chevron deference, sort of not looking at anything just because an agency is saying so, their say-so. So in this intermediate sphere, I actually think judges could use judicial scrutiny to do some good. But I don't have I'm in the process of exploring this and finding some pretty shocking case examples of this as well.
Can I just say briefly that there's a transparency element to benefit cost analysis as well. It allows people to step up at conferences like this and point to absurd numbers and maybe build some public pressure that might act as a check.
Here. Let's move to the second microphone back there. Sir.
Harry Lewis from New York. The Roman poet Juvenal famously asked, who will guard the guards themselves? This panel, it seems to me, is asking the question, who will regulate the regulators themselves? But to my comment in question, in New York at least, we are fortunate to have the participation of members of the federal judiciary at our events, and Chevron has been extensively discussed, Chevron deference. The concern I've heard from those judges in informal settings is that Chevron really is, in some respects, a floodgates kind of protection for the federal judiciary. And of course, Justice Scalia famously was very concerned that, loosening federal jurisdictional requirements, things of that sort, would inundate the federal judiciary with literally a flood of cases in these areas, which it would be unable to manage or to handle. So my question is, if Chevron deference is a kind of floodgates control on inundation of the federal judiciary, is it realistic to consider repeal since, and you have to consider prudentially the question of how is the federal judiciary going to handle a massive influx of cases of this type, reviewing regulatory decisions. So my question is the prudential question. How would that happen? Giving them more law clerks? How would that happen?
Yeah. Maybe we can send this to Cary. Cary's written an article on the Chevron staircase, and obviously Katherine's written as well with regard to that second step. Cary?
Sure. I would just say that, I think getting rid of Chevron is a nice rallying cry, but the actual empirical evidence shows that there really was very little change in the amount of deference that courts afforded agency, or at least the win rates before Chevron versus after Chevron. And there's, as your question I think suggests, there's strong, compelling prudential reasons for judges to defer to agencies, even in the absence of Chevron. And those reasons predated Chevron. In some sense, Justice Stevens' decision was really trying to wrap up in a framework prevailing understandings of how courts should respond when agencies have interpreted a statute. And those prudential reasons will still exist, even if Chevron is somehow overturned.
So, Judge, I was going to encourage you to say a word or two, because before the panel we talked a little bit about this, and I think it's a really interesting question, and one actually that might really affect state courts as well. So do you want to, I mean, I could characterize what you said, but maybe you should just say it.
At state court level, you're seeing this change. In Wisconsin, of course, we have a decision that's recent called Tetra Tech, where they're grappling with this level of control in where people are going to defer or not. I think on the state court level, at least, having been a former state court judge, it's much more a circumstance of time and resources to be able to address the complexity of the question. And once those exist, then those types of arguments, especially by strong advocates, might have purchase with regard to the state courts. Let's go back to the third microphone in the far back. Sir?
Thank you, Your Honor. Tony Francois with the Pacific Legal Foundation. My question has to do with cost-benefit analysis. It perhaps follows up on the question about the fish. It seems there's potentially a couple of ideas that are in tension. First, with the proposition that regulation should be reserved for cases where there are market failures. So regulation is necessary. But on the other hand, cost-benefit analysis is an important part of how to regulate. And I'd be interested in Susan Dudley and the other panelists' thoughts on how you do cost-benefit analysis, how you assign costs and benefits in an area where there isn't a clear market value that itself precludes the need for regulation.
Susan?
Yeah, that is challenging. EPA has been working on that challenge for decades now, how to different ways of measuring by observing other markets to be able to understand what the costs and benefits are. It's never going to be perfect, and I do want to just reiterate and agree with what Cary said about one of the real values of doing that analysis is the transparency. So it's a transparent accounting of what you know and what you can anticipate about what will happen under different scenarios. So, you know, I definitely don't want to be criticizing benefit cost analysis. I think, to paraphrase Winston Churchill, it's the worst of all possible tools except for everything else we've tried. But I do think that first step is very important, and that's where sometimes we go wrong. We jump straight to the benefit cost analysis, which really it's a socialist planning tool, and we should start with, we only need to do that after we've asked that first question of, does this need to be a collective decision in the first place?
And there, first, in addition to the kind of the preference solicitation, the contingent valuation techniques, and we get into the weeds with all of those that are available. It's also true that even under Executive Order 12866, that a benefit cost analysis of a prospective rule doesn't need to be one which has monetized estimates of benefits or costs. I mean, qualitative benefit cost analysis in some circumstances may be the best that one could do.
Let's go to the first microphone. Sir.
Thank you so much, Judge. So as Professor Sharkey prepares for her trilogy and tries to explain both the Arizona revolt and also the muddle in the states that have yet to revolt, I have a theory that I'd like her and perhaps the other panelists to comment on. My theory is it's the tyranny of the poorly prepared judicial law clerk. I'll give my own state as an example, and I'm a state ALJ. Our state APA, our Administrative Procedures Act, predates Chevron by nearly a decade. It comes from a very different political tradition, very different features, very different incentives, very different assumptions about the difference between executive and legislative branch relations as opposed to the federal APA. However, you get a poorly trained judicial law clerk who goes to clerk for a state court, not in Wisconsin.
Thank you.
And says, oh, I have an administrative law question from a state agency. There's this often cited case, Chevron. It's hundreds of cases have been cited. So, and it's from the Supreme Court, so it must be binding authority. And so we assume that the relationships between Congress and the federal executive branch are the same, not only in every state of the union, but in this particular state. And in Minnesota, nothing could be further from the truth. So the states that have realized this, like Arizona, are revolting, and the others are muddled because they haven't yet revolted. So what say you?
Yeah, no, that's very, I thought you were going to say you'd be in the movie version. But maybe I'll want you on the trailer once somebody wants the movie, wants to buy these rights. In all seriousness, it's an intriguing question. Judge Brennan and I were discussing this a little bit too, because as I said in my early review of this mass of state cases, I've been intrigued that there seems to be a replication of many of the arguments that are made at the federal level, but very little analysis about how these factors could differ when we're talking about state relationships. And I was intrigued as to why that would be. So the tyranny of the poorly trained law clerk could be one hypothesis. And all I can say at the moment is I too have recognized that there's dramatically little discussion about how we might agree with Chevron at the federal level, but things are different here, and here's why. So I appreciate the comment, and I think it's a very interesting one. Yeah.
Other commentary from the panel? Let's move to the second microphone, sir.
Thanks. So my question is born out of just some day-to-day experience wrestling with the Leviathan, and I guess what I hope for is some empirical comfort that having the independent agencies conduct more formal cost-benefit analysis wouldn't backfire. And so what at least it feels like very much when you deal with some of these agencies day to day is that they see making you spend money as a benefit. And I think the logic goes something like you're spending money, you're contributing to the economy, and therefore the federal income tax revenue will go up in some downstream way. I'm pretty sure that's why they're doing it, unless they're just crazy or counting beans or something like that. But they definitely seem to see imposing costs as a benefit in and of itself of regulation. So is there any study that would say making them actually estimate how much money they've made people spend would have them do less of that as opposed to more?
Well, I think the research that we have doesn't really apply to the so-called independent agencies because they haven't been subjected to these requirements. Although I do think there's some, I think Jerry Ellig at Mercatus has some...
GW.
Or GW.
He's my colleague.
Okay, at GW now, has some papers that suggest that the SEC, since the Chamber of Commerce litigation, that they've really ramped up. I think Kathy referred to this as well, have ramped up. But in terms of whether benefit cost analysis can make a difference, most of that research has been focused at the executive branch agencies. Dick Morgenstern has a nice book about the role of economic analysis in EPA rulemaking, and he points to, the book contains 12 case studies, and only one of which apparently did the benefit cost analysis really affect the decision in a very meaningful way, but it was an important one. The elimination of lead from gasoline came about precisely because the benefits so much outweighed the costs in an administration that otherwise probably would not have been inclined to impose another regulatory burden on industry.
May I?
Yes, Steve.
Jump in just quickly. I think the question tends to underscore the benefits of subjecting those regulatory agencies' rulemaking and cost-benefit analysis to a WIRA review, because that kind of benefit analysis, claiming those cost expenditures and secondary effects in the economy as a benefit of the regulatory decision would be, I mean, correct me if I'm wrong, would be rejected by a WIRA as an improper analysis of the, or measurement of benefits from the rule. So at the Department of Transportation, we issue a lot of rules. It's a heavy regulatory department, and a lot of them have impacts on the economy. And some of the deregulatory actions we're taking, for example, the current proposal for a new comprehensive reset of the CAFE standards, corporate average fuel economy standards for motor vehicles, we believe will have very significant positive economic implications for the economy as a whole, but we don't try to capture those and measure those secondary economic effects and stimulating economic effects as a benefit of the rule. You've got to confine an appropriate cost-benefit analysis to the direct cost effects that you're imposing from the rule and the direct policy objective measurable benefits that flow from the purpose of the rule and the market failure or compelling need that you've identified to address, and not all of the secondary and ripple effects. And I just think it's too easy for an agency that's not subjected to the rigor and consistency of OIRA interagency review to justify a rulemaking action based on its interpretation of the benefits and the secondary benefits and the whole kind of broad sphere of benefits that it imagines from a proposal. And it's just too easy for the agency in that case, based on its own view of its own little area of concern, to justify almost any regulatory decision it might want to make. So I think it's a good example of why interagency review through OIRA is important for the integrity and consistency of the process, reasonableness.
Cary?
Yeah, can I just add, without really disagreeing with that, and with all due respect to anyone from OIRA, I think it's also important, just to be honest, that it's no panacea, and that, there's a lot of analyses that do go through OIRA that maybe are ones that could have been done better. At least that's the upshot of some research that Bob Hahn and Patrick Dudley did. They published some papers now. It's going back some years, and it was surely even, I think, before Susan was at OIRA. But they showed that, a surprising number of the benefit cost analyses that agencies put forward, even under the 12866 framework, don't really meet the standards that OIRA really puts out as to what would count as a good regulatory analysis. Maybe, I think sometimes that's just because of the inherent nature of the problem. I think John Graham found that when Department of Homeland Security had to put out a lot of security regulations very quickly after 9/11, there wasn't time, or maybe even the research base yet to develop the kind of sophisticated regulatory impact analyses. But surely it's not a perfect process either. No. But the question really, I think, always should be against what counterfactual, and is this institutional structure better than the alternative?
Well, the process can always be improved. Yeah. And I would just offer that it's the president's responsibility to improve the process and to achieve the strongest, most efficient management process for the executive branch. And if the president fails at that, the public should punish the president in the next election. And obviously, OIRA is never going to be a big campaign issue in a presidential election. Nevertheless, I think the public generally has an impression and can understand when the executive branch is functioning efficiently, when agencies as a general matter are overreaching and over-regulating, and that's having a stultifying effect on the economy. And I do think those are issues that are the public is aware of, and that are important in presidential election years and should be.
I don't know why presidential elections don't win and lose on regulation. That certainly does for me.
Or OIRA.
Or OIRA. But OIRA, and getting back to Cary's point, OIRA is a very small staff. It's fewer than 50 people to review all the significant regulations of the executive branch. And it wears three hats. One is the analytical hat, reviewing the analysis. President Obama called it a dispassionate and analytical second opinion on agencies' analysis. The second is the interagency coordination, which is very important to make sure that agencies aren't doing things that conflict or overlap. Plus, you can get real insights from broadening the number of people who look at something. But then the third is that it is part of the executive office of the president. And so it ensures that the elected president can hold agencies accountable. So I agree that it's not perfect, but I think the counterfactual is, what would things look like without OIRA? And I know agencies will tell me that the way I can make my own agency do better analysis, so the economists and agencies, because I can tell them this is not going to pass muster with OIRA. The type of analysis you described, the economists and agency could have stopped it by saying, we're never going to get that through OIRA. The other thing is that you don't know what goes on behind the scenes, and there are a lot of times when, during the interagency process, things always could have looked worse. And so that's the thing. If you talk to folks at OIRA, they say, yeah, it may not look great the way it came out, but you should have seen what it looked like when it came in.
Let's go to the first microphone.
Yes, hello, my name is Jeff Bristol. I'm a JD candidate at University of Michigan, but for longer than I'd care to think, I've been an anthropology candidate at Boston University. And so my question is addressed to Professor Coglianese.
Go blue.
Yeah, go blue. So my advisor at BU is actually Shahla Hari, who's a student of Falkmore's. And so when you use the term semi-autonomous, I think it's interesting. I'm a little confused by exactly what you mean. So Falkmore, when she was looking at the semi-autonomous social fields, she was looking particularly at societies that didn't have a state. And so the semi-autonomous social fields were kind of incorporated in her idea of reglementation, legal orders that kind of competed with one another on more or less equal terms, and therefore balanced each other out. But if we look at the bureaucratic structure of the federal government, clearly it's routinized, it's rationalized in kind of a Weberian sense that allows power to be concentrated and competed with. And so I have a difficult time seeing exactly how that idea of semi-autonomy transfers from a kind of laissez-faire context where powers can balance each other out through competition into a more centralized, kind of routinized context that we have in the federal government. Because technically one could argue that the independent agencies are already semi-autonomous. They compete with one another, with the public opinion, through Congress to kind of police and control their own powers. So I guess what are the exact bureaucratic ligatures or things like that that you think would really make these agencies truly semi-autonomous according to your understanding?
Well, I think if you go back to Falkmore's 1973 paper in the Law and Society Review, she actually very explicitly says this notion of semi-autonomous nature of law applies in complex societies as well as the more developing parts of the world at the time she was studying. So it's not a notion that is just time-bound or culture-bound. It is a notion about law and its relationship to society. She even quotes Philip Selznick, who wrote in a 1959 article, even before her, that we should abandon the argument of an independence between law and society, and probably Selznick was reading legal realists before that. What I mean by it is simply to say that when we look at actually the behavior and the incentives, the pressures, the forces that are influencing and shaping behavior of folks at agencies, that law is one force, and those formal structures of that we associate with an independent agency are certainly one factor, but they're not alone. And that there's a degree, so independent agencies are not really as independent as they make out, but also, on the flip side, is that non-independent agencies are at times much more independent. The Food and Drug Administration has for years inculcated a degree of independence about its drug approval process that is not what you would expect from an agency that has an at-will administrator. So the point is that there is autonomy in both kinds of agencies, but it's a semi-autonomous nature. And in fact, that's really what we're aiming for as maybe as a normative or moral matter when it comes to the administrative state. Yes, bureaucracies that have routines, bureaucracies that have a degree of autonomy to do credible, good faith, solid analysis, but also agencies that are answerable to presidents, to members of Congress, to the public. And they are operating going forward in a manner very similar to, I think, what Faulkmore was talking about complex societies in general.
Thank you. Our last question here in the front.
Thank you, Judge Brennan. My name is Adam Griffin. I am the student chapter president at North Carolina School of Law. My question is for Mr. Bradbury, but if anybody has comments, that'd be great. It's related to the constitutionality of interagency communications and transparency requirements. Mr. Bradbury, I think you made a statement to the effect that requirements that mandate interagency communications be transmitted to OIRA for review might be unconstitutional or something of that nature. And I was wondering, what requirements on transparency and interagency communications would be beneficial and why certain ones might violate the Constitution?
No, I was referring to a statute that would purport to require public disclosure in the rulemaking docket of communications within the government between an agency and OMB on a rulemaking matter, for example. So it's just simply the notion that there's a deliberative process within the executive branch, and the integrity of decision making is often dependent on preserving the confidentiality of candid deliberative interactions, pre-decisional. So what you want is to encourage all participants in the decision-making process to share their most candid assessments, their most candid recommendations and concerns in terms of the upside and downside of taking certain actions. And to the extent that there's a requirement that those interactions and assessments will be publicly disclosed, and if the communicator knows that in advance, there's necessarily going to be some dampening of the willingness to share candid assessments. It's just basic fundamental principle behind the deliberative process privilege within the executive branch, which is a legitimate recognized basis for the president to assert executive privilege, for example, in response to an oversight request from Congress. It's also protected in the Freedom of Information Act. Interagency and intra-agency deliberative communications that are confidential in nature and that are reflective of these candid back and forth in a pre-decisional process are protected from disclosure. And to the extent you have a statute, and there are some, that would require that all communications between the agency and OMB within the government as part of the interagency review of a rule must be disclosed publicly in the docket of the rulemaking. That's something the president could require, something the president could, see fit to institute. And OIRA does have a process for doing that. But to the extent Congress would require it for all communications and purportedly leave the president no discretion to determine that certain deliberative, confidential communications need to be protected to protect the integrity of the process, then I think it does raise serious constitutional concerns.
That's all the time we have. I'm sure you can all see why these excellent speakers were chosen for the showcase panel. Please join me in thanking them.